Good afternoon, everyone. My name is Chris Justice. I'm here today, as often is the case, to hopefully answer all of your questions, all things related to employment law. So do get them in while you're here, and I'll do my best, as always, to answer as many as I can within the time that I'm given. But I like to, as many of you may know, like to start off with some topics that are still coming out in the news, some trends that we're seeing in the news. The first one, again, I've talked about this before, but the first one has to do with a number of layoffs, a number of terminations that are occurring throughout a number of different sectors. And so in these cases, a lot of these employees who are being let go are being offered a severance package. And I thought that it would be good to start off by talking about just some things to be mindful of if you're in a position where you have a severance package. Some of the things you'll often see are, of course, what the severance offer itself is. And a lot of cases, your employer is going to tell you that part of the offer they have to give you, and another part of the offer they're willing to give you so long as you sign a full and final release. And then that usually results in you getting a little bit extra money. A lot of people look at these packages and think that because their employer is offering them above and beyond what the bare minimum entitlements are, that is going to somehow be seen as a reasonable offer when the reality is that it's not. There are a lot of cases where you may get offered a certain severance package, but after actually speaking with an employment lawyer, you find out that what they're offering you is a third or even a quarter of what you could potentially get. So don't think, first of all, that when you look at these sorts of things in a severance package, that it's a fair and reasonable severance package. I would say that if anything, 90% or around there of packages that are given to people are not packages that I would deem to be fair and reasonable. So all the more reason to not assume that the offer is fair and to at least get some legal advice before accepting, that is. Another thing that I come across a lot when people are given packages is the deadline by which they have to return the package signed. And a lot of people will call me and be freaking out a little bit about the deadline and how they have to get the package signed by a certain day, usually a week after they're given the package. Otherwise, they're being told that they will lose a part of their severance package. However, for the reasons I just mentioned earlier, which is the severance package is never usually close to being fair in the initial instance, whether or not this deadline comes and goes, first of all, is immaterial. It doesn't really matter because in most cases you're going to want to fight for more severance. But secondly, that deadline is there only to put you under some pressure. It doesn't mean that if you wait past that deadline that you are no longer entitled to what you were entitled to before. It doesn't mean any of that. And as I say, oftentimes you're owed more. So if that's a concern of yours, a lot of times I'll tell people, ask the employer for an extension just to give yourself peace of mind. But do know that that is not a strict deadline you have to meet and that your rights just don't simply extinguish if you wait past that deadline. Again, if you're ever in doubt, give a lawyer a call. First of all, give us a shout and we can let you know if there's anything to be concerned of there or if, as in the most cases, the deadline is pretty much meaningless. A third thing that I come across when it comes to people getting their severance packages has to do with, what exactly constitutes or what makes up the number of weeks or the number of months that are being offered. So if, for example, you are an employee who's been offered 6 months of severance, is that 6 months of your base wages? Is that 6 months of your base wages and your bonuses or your commissions? Does that include things like your benefits for 6 months, pension? So there's a lot of things that make up our compensation, our remuneration in a lot of cases. And so whenever you're looking at whether a package is fair and reasonable, you want to sort of get a sense of, does it include everything that you would have got had you been there for the next 6 months or 5 months or 12 months, whatever the package is. So you want to make sure there's everything included there, that it is a total package. That's sort of a third thing that often will come up in my discussions. But either way, I've said this before, and even in today's discussion, get legal advice. Before you sign anything, get legal advice, because once you're given a package, if you decide to sign that release, even if it's maybe not the best choice or a decision that was made without legal advice, it's still going to make it next to impossible for you to go back and negotiate more. So as much as you're worried about losing a couple months here or there, if you don't sign it, you could end up signing it and then realize after the fact that you just threw away, potentially tens of thousands of dollars, if not more. So definitely don't sign the release before getting some legal advice. In all likelihood, the lawyer is going to recommend that you at least negotiate for a higher price. And then depending on where your employer comes back with, whether a lawsuit or not is required. But in terms of the negotiations, when it comes to severance packages, in most cases, it only takes maybe a couple months or so to fully negotiate a package and get something fair and reasonable, assuming you don't have to commence a lawsuit. So it's not necessarily going to take a ton of time. Don't think that you're going to be locked into a certain legal process once you get a lawyer involved. A lot, and as I say, the majority of these cases, even when negotiated, are still settled reasonably quickly. There was one more thing I was going to talk about just before I get into some questions here, and that had to do with what happens after you're given the severance package. So say you're given a package that's worth 6 months, but then you go and find another job making similar money very soon, maybe within a month or two. If that happens, it's going to make it more difficult, unfortunately, for you to secure a bigger package than 6 months. Somebody's job search efforts, whether or not somebody gets a job sooner than later, if they're still negotiating a severance package, that can kind of throw a wrench into their plans. People that secure work sooner, in general, are not going to be getting as much severance as people who it takes longer to find a job. As I say, right, wrong, better, for worse. So you want to be mindful of how your job search efforts will impact things. You still do have a general obligation in law to go out and look for other work, but it's once you secure that job, once you replace those lost earnings, that's when sometimes the courts and the judges will say that you're not owed as much severance, because the whole point behind severance is to tide you over till you find your next job. And a lot of people think that regardless of when they find work, they should be entitled to the same amount of severance. And while they are guaranteed a certain minimum, finding work earlier can still affect the potential maximum in these cases. So just something to be mindful of, and probably something to discuss with the lawyer once you have a consultation set up or get some legal advice. But I'll talk a little bit more about some topics in the news if I have time. But I'm just going to get into some questions now. The first one's from Ace on YouTube, who's saying that they were let go in November due to misconduct, quote unquote misconduct, and they've been denied EI. Very relatively common situation, unfortunately. You get accused of something that is reserved normally for the worst of offenders, and then that can impact your ability to get EI. But I will say that if you've been accused of committing misconduct or there's cause that's alleged in your termination, you should still generally apply to EI, because there are cases where EI will still give you EI, even if your employer let you go for cause or for some alleged misconduct. So it's good that you've applied, Ace, but yeah, unfortunate that you were denied, though there might be some possible further options going forward there. And Ace is saying that they've got to sit in front of the tribunal and found out that their ex-employer fabricated paperwork that was supposed to sign but never told me. So it seems, Ace, that you've already gone through a little bit of a process. And if you're telling the truth, that, yeah, there's been some fabrication, I would imagine that that's going to work heavily in your favor and against your ex-employer. I'm not sure exactly how that is panning out, but nonetheless, my comments regarding the misconduct and those situations in EI still stands. But I think without some further information, Ace, I'd have to go off of some more info before I can fully answer your question. Though, as I say, if you found out that your employer fabricated paperwork, then that's in most cases going to lead to additional damages for that fact. Sometimes, these people think about these cases as strictly severance-based cases where they're just wondering if they're owed severance. But there is also the way in which someone's terminated, There are things that happen maybe outside of the termination itself, so to speak, that can lead to additional damages, whether it's fabrication of evidence, forgeries, that kind of stuff, or maybe just the way that you've been treated in the build up to the termination or afterwards. So anytime I have a consultation with someone, I try to get a full sense of what the issues at play are and try to, raise these questions, because some people may, again, only think that they're after the severance piece alone, but there are oftentimes facts and circumstances that can lead to extra compensation. I've got another question in from Stephen on YouTube, who's asking whether or not you can suspend an employee unpaid as part of a progressive disciplinary process. So I will say that in general, when it comes to unpaid suspensions, the employer runs a greater risk of that being deemed a constructive dismissal, which is a significant change to the terms of your employment. A lot of times when someone's placed on a suspension, assuming it's for valid reason, maybe in relation to disciplinary action, or maybe there's some kind of investigation going on, but there hasn't yet been an outcome or a conclusion reached, it can be acceptable for the employee to go off on a paid suspension until that sort of issue is determined. But to just simply penalize somebody with an unpaid suspension as part of a disciplinary process, I think without a bit more information, Steve, I wouldn't know for sure. But again, I will say that unpaid, anytime it's unpaid, there is that greater risk of the employer not actually having the ability to do that. And also a question is, how long are they on suspension for? Because if you're going unpaid for, several weeks or several months, or for an indefinite period of time, then that also is going to factor in, I think, as far as whether the company's decision is legitimate or egregious. And as I say, it could actually give you the opportunity to leave that company as though you had been let go and go after your full severance rights. But it may also come down to exactly what's been going on, what the discipline's been about, why it came about, how long the suspension's going on, and sort of the context around it, because there are some limited situations where it could be acceptable, but in most cases where it's unpaid, and especially for a long period of time, you do have options to either stay there and just, continue on, wait out the process and keep working, or possibly draw a line in the sand and say enough's enough. You guys don't have the right to do this, and go after severance. But before you have those communications or go down that pathway, you definitely want to give us a call, and we can kind of flesh out, I think, in greater detail, whether and to what extent there are risks in your case, and maybe what your potential earnings or amounts owed would be. It's another thing to say that you've been suspended after 1 year, but if you're an employee with 20 years of service and this has happened, then that too could factor in potentially greatly as far as what your possible options are, what your possible recourse is. But thanks for the question, Stephen. I've got another one in from Stephanie, who's asking what happens when your ex-employer keeps rescheduling your human rights tribunal mediation. Okay, so you've gone through this human rights process, you're getting to this mediation point. Stephanie's saying that they were 3 weeks away from mediation. All of a sudden, they can't make the date. It's been almost a week now. We responded back saying we can make any date work. Will human rights eventually move forward with or without the response? So that's a good question. I will say that in some respects, it depends on the reasoning for the cancellation, of course. I mean, sometimes, and not just the human rights context, but in general, when you go down the litigation path or otherwise, when you set dates for things, it can happen where a rescheduling needs to occur. And assuming it's in good faith, for the most part, that's going to be allowed to happen. But it's particularly when it comes to multiple rescheduling that it can be an issue. And it also can come down to the reasons for the multiple rescheduling. So someone may be able to get off with one or maybe two rescheduling situations, but I think beyond that, it's going to look more suspicious. And even with the first or the second rescheduling, it could also depend on the rationale behind it. In my experience with the human rights people themselves will eventually set a date, a unilateral date that no one can avoid, rather than continuing to allow people to push things back and back and back. There's no exact science to it. It just comes down to the circumstances. So maybe that's something to discuss specifically with the Human Rights Tribunal people themselves, as far as is there a specific point. But in general, I know that there is. It's just a case by case basis. I'm not sure, Stephanie, how many times they've rescheduled. You'd mentioned one incident where they couldn't make it. I guess if I were you, I would just be following up with them and the tribunal as far as getting a new date. Seems like you're quite available. So I would follow up, and I would like to think that, maybe within a week or two, you'd get an answer, although I do know the tribunal themselves are a little bit behind the eight ball, so to speak. But I'd follow up there. I don't know if you've got a lawyer involved yourself in your case, but maybe having them step in too. Otherwise, I think the only thing you can do is just continually send those emails on a regular basis, or perhaps call the tribunal to get some definitive answer. I've got an email or a question in from Frank on Facebook, who's saying they got a doctor's note for their back pain, and they were put on light duty. Frank's asking whether his employer can send him home. So it would depend on the nature of your condition. So if you're saying that your doctor has you working light duty, the question would be, how much of your job can you do? If, say, for instance, you can still do 80% of your job, or something in that ballpark or greater, even if it's on light duty, then there's going to be more of an onus on your employer to accommodate you, even if it's a bit of an inconvenience or burden to them. On the other hand, if your back pain or your limitations are such that you can only do 20% of your job, then your employer is going to have a lot more leverage to say that the accommodation would go too far for them, that there would be this undue hardship placed on them based on you only being able to do 10 or 20% of your job, let's just say. So it kind of comes down in a lot of these cases to how greatly affected you are. But people should know that even if you can't do all of your job, if you're still looking to go back to work on some form of modified duties or modified work, again, it doesn't have to be at 100%. Your employer can't generally just reject that and send you home. They can't, in a lot of cases, or even in most cases, insist that it's either 100% or no percent. That's when the accommodation efforts start to get more unreasonable, and where your employer can actually be found to fail in their duty to accommodate, which can open up a can of worms as far as owing you severance, maybe owing you human rights related damages. So it just kind of comes back to how much of a burden, if anything, for lack of a better word, would be placed on your employer by having you work light duties, and that kind of determining how reasonable they are, or at least how the law would consider how reasonable their position is. But definitely give us a call. It seems like, as I say, there could be a potential for a lot of compensation owed your way if there's this significant breach, and it may give you a means of leaving your employer if that was in your mind's eye. But give us a shout. We'll flesh it out and take you through all the possible options in your case. But thanks for the question, Frank. I've got another question in from BB Smooth on YouTube, who's saying, what if your employer makes a number of small changes to your position over several months? Small changes individually, but large change overall. Do you have any rights? And it's a good question, because the term constructive dismissal refers to when there has been or have been significant changes made to your job. I think that when it comes to a number of small changes happening to your position over a number of months, maybe one question would be, how many months are we talking? Because if, let's say, a number of small changes happen over 3 months, and for the first month or two you were willing to accept it, but after the third month of changes you weren't, and assuming that did amount to a large change overall, I think it's reasonable to maybe give you a little bit of leeway as far as, those first 2 or 3 months are concerned, because of course, to your point, someone may think that there's no further changes to come. So they think there's no risk in agreeing to small changes, but when it adds up, that's when it becomes an issue. So I think if it were a matter of a few months, it wouldn't be so much of an issue to just wait and then make the claim that there's big changes. But when we're talking over a year or two or more, a lot of times the employer will argue that you never objected, for the other changes, that it's been 6, 12 months, 18 months since those first changes were made. And that's when it gets a bit trickier in terms of having it all accumulate. Although I think you could still make the argument. It's just that in general, I think you got to be cautious when it comes to accepting the small changes either way. You want to maybe communicate things to your employer, even if the changes are small, something to the effect that to the extent you are agreeable to a small change here or there, it's on the condition that, there's not going to be a number of other small changes happening afterwards, that it's sort of this conditional acceptance. And of course, getting things in writing is always recommended. And at least that way, you kind of paper your trail. You have evidence that clearly shows you were taking on those changes on the condition that it didn't keep going on and on and on and on. I think, if anything, that would give you a greater case, or at least more leverage, if you did decide at the end of the day, this has added up to too much. But without that, I'm not going to say you have no case. I still think that if something adds up to a big change overall, you can still very easily make the argument that you hadn't thought this and that this is the straw that broke the camel's back. I think if you are in a position where maybe you haven't papered your trail as far as these changes occurring as they occur, but you have nonetheless reached a point where it's added up to a big enough change, I think one good thing to do would be to notify your employer. Usually when it comes to constructive dismissals or, big changes overall to your job, you want to have some record at least of objection, where I guess in your case, BB Smooth, you would say that, in good faith, you accepted these changes because at the time you didn't consider them that great, but you've realized that over time things have accumulated such that it's a huge change. And then you can almost have sort of like a before and after picture that you would send to your employer and say, this is how things were before the changes occurred. Now this is how things are after. And as I say, if it's a big change, I think putting that to them in writing, stating your objection and that you want them to start actually clawing things back or reducing the changes, or, providing an assurance maybe that there will be no further changes. I mean, depending on your tolerance level. But again, at least you now have a record of an objection being made, sort of a substantiating a basis for the objection, and then at least giving your employer that chance to rectify things. And if they say to you, no, too bad, so sad, it's our way or the highway, then at least you've got that record. At least you can show you tried to resolve things in good faith, and your employer just simply said, no, that's just not going to happen. And so now you have greater leverage to go after them if you want for a possible severance package, maybe even additional damages. But I think this is also another situation where having a good sense of what period of time we're talking about, the number of changes, because sometimes people may think it's big, but the law may say otherwise, or vice versa. Whether there's been any record of sort of complaints being made or concerns or disgruntlement or anything along those lines. If it is the decision that you'd want to leave, of course, before doing that and basically, not having a job to land to in most cases, you want to make sure that you've got a strong case up front before usually taking that plunge. So give us a call for sure if you're in a situation like this, or if anyone is. And again, we can consult you further, give you advice, and kind of at least give you an idea of what your best options or what your options overall would be. I've got another question in from Carrie, who's saying that they are a residential house cleaner. They're on a set salary every 2 weeks, and they're eligible for overtime when they work more than 8 hours a day. They've been there for 2 years and haven't received anything. Also, they're required to pick up and drop off coworkers at their houses every day. Should I be getting paid for that travel time? And yes, I think you should be getting paid for the travel time. Now, if you're saying you haven't received any overtime despite working overtime, that's another huge issue. A lot of cases, or a lot of people come to me with cases where they may have realized after the fact, for whatever reason, that they're owed past wages or past overtime. Number one, I usually say if there's an ability to prove what you're owed, the dollar amounts, what days you worked overtime or didn't, or how many hours we're talking about, and whether there's any record of that, that certainly goes a long way. These are actually things that the Ministry of Labor can also assist with. Normally, I don't recommend people going to the ministry when it comes to severance specifically, because they can only do so much. But when it comes to just complaints relating to past wages or OT that's owed, that's something they can assist with, because that's owed by virtue of employment standards legislation, and that's what they look to enforce. In most of these cases, it's for time already put in, efforts already done. So it's not really, or at least shouldn't be, a matter of contention. There shouldn't be as much of dispute. But that said, I do come across a lot of situations where the employer will deny certain things, or where the employer will say that there's some sort of right they have to do whatever it is they're doing, or, a number of things can pop up, which can potentially complicate things. And again, all the more reason to get some legal advice first. But, it does seem like if you've been there for 2 years and never received any overtime, or you've been having to pick people up and drop them off and you're not getting paid for that time, depending on how much we're talking about, the potential could be great. So definitely give us a call if you're in a situation like that. I've got another question, I think, in from Paul on YouTube, who's saying, does clicking to win a strong effort for saying this channel? Paul's question is, what aspect of unilateral-based decisions to impact the terms? Sorry, Paul, I'm not understanding your question. If you could resubmit it, that would be great. But I do see your comments about, our channel having great content. So appreciate the good words there. We try to help out as many people as we can. And I think that just by giving people an idea of the potential of things that they're owed, they may not even have thought of it before coming to our channel. So any information we get out there that could potentially lead them to talking in more detail with a lawyer. As I say, a lot of times you then discover that your rights are far greater than you thought they were. So hopefully we're doing that through this channel. I've got another question in from Snuggles on YouTube, who's saying they've been let go at the end of their 3-month probationary period and they weren't given a fair chance. Do I have any rights? Yes, you do have rights. First of all, if you're let go in a probationary period, you don't want to assume that you're not owed any severance. A lot of people will assume that because it happened in the first 3 months, that therefore the law says they're not owed anything. But there actually has to be a contract in place that you've signed that has a fully valid probationary period clause. A lot of times it may be there, but not valid. Or in a lot of times there may be no reference to probationary period or termination during a probationary period. And if not, you're likely going to be owed severance, which, depending on your situation, even though you might have only been there for a couple months, could lead to several months of severance. So just one thing I want to address off the top. But as far as not being given a fair chance, I think that if the purpose of a probationary period is to assess the fit for both you and the company as far as an employment, working relationship is concerned, then yes, the idea is to sort of assess that in a fair and reasonable chance. So if you're not given that, if you're set up to fail, thus sort of defeating the whole purpose of the probationary period, then you could potentially have rights above and beyond your severance package. There could be additional damages owed to you for bad faith, or for breach of contract if the contract sets out, the purpose of the probationary period. But of course, again, it would come down to the evidence you have to show that you were or weren't given a fair chance, because I assume the employer is going to probably push back in a lot of these cases to say, no, we gave them a fair chance. But absolutely, not only severance, but additional damages can be warranted. So give us a call and we can kind of talk you through it some more. I'll answer another question, but then I've got to go. But the last question for the day is from Francis on YouTube, who's asking, what happens when your employer says they won't pay severance and they have given less than 3 months notice? Francis saying they worked for the company for 20 years. The boss is retiring and closing business. So 20-year employee, definitely don't want to accept 3 months notice and that's it. You could be owed upwards of 2 years. So on the face view of it, it doesn't seem like it's remotely close to being reasonable. In some situations, the employer can satisfy its bare minimum obligations to you by just giving you 3 months notice. So if this company is a particularly small business, it has certain minimum obligations to you that a larger business won't. So if you've been at a company for 20 years and you work for a small mom and pop shop, your bare minimum rights, just minimum, would be 8 weeks. But on the other hand, if you are 20 years in at Walmart or Amazon or a bigger company, then your bare minimum right would be 28 weeks. But either case, your maximum potential is still upwards of 2 years. So the only difference between smaller and large companies is what they owe you at minimum, but not necessarily your maximum. So as I say, it could be the case that being given less than 3 months notice satisfies this employer's bare minimum obligations to you, but certainly nowhere near what you could get. So my general advice to you there would be give us a call, because there's a good chance that you're owed not even just 3 or 4 times the 3 months. You could be owed 5, 6 times that amount, if not more. So you want to make sure you don't forego that. Give us a call and we can definitely flesh that out for you. The other concern I have with the comment is that your boss is retiring and closing business. So I want to say, first of all, that just because a company is closing up shop or business does not mean you're owed less severance. That's another sort of misconception I'll just say or dispel. But if your boss is filing for bankruptcy or going through some insolvency process where there's literally no funds to be had, then that could be a problem. It's a very relatively rare occurrence, but if there's no money to be had, then the old adage, you can't get blood out of a stone, kicks in, and you may, as bad as it may seem, be limited to 3 months or something much less than 24 months potential. But as I say, that's relatively rare, and it doesn't extinguish your rights otherwise. So I think your potential is still there without having any further info. And definitely give us a shout. But that's my time today. I thank everyone for joining. Definitely get your questions in on any future episodes we've got. As far as disability is concerned, if you've got questions relating to that, maybe you're in a bit of a fight with your insurance company, you've been denied benefits, long-term, short-term, Martin Willems is going to be there this Tuesday, which is tomorrow, to answer your questions. So definitely tune in if you've got a question for him. And then as far as any employment stuff concerned, I'll be back. Others will be back so we can answer your questions at that time. But thank you very much. Enjoy the rest of your day. Bye for now.